SJC-12093, Commonwealth v. Brandon Rodriguez.
Good morning, Mr. Michael. I see you're pinch hitting.
Yes, good morning, Mr. Chief Justice, and may it please the Court. I am representing the Commonwealth today in this case.
Hold
on. Hold
no,
on.
No, actually, the clock's going. I'm sorry. Please proceed.
Thank you. The facts of this case are relatively simple and straightforward. The defendant was a friend of the victim's son. He was invited to the victim's house in connection with a funeral. At some point during the visit, he spotted possibly rummaging through the victim's jewelry box, standing in front of the open jewelry box. He's confronted and claims that he took nothing, but the next day, the victim noticed that a ring was missing from the jewelry box. The victim's daughter then undertakes some investigation of her own, goes into social media, and lo and behold finds a photograph of the defendant with the stolen property. He has the ring on a chain around his neck. On this basis, the defendant is arrested and he's charged in the district court with receiving stolen property, that is to say the ring. The judge, however, during the proceedings, adopts the view that it is legally impermissible to charge or try a defendant for the charge of receiving stolen property when the evidence might tend to show that, in fact, he was the one who stole the property in the first place.
And that's just wrong.
The parties all agree that that is a mistake of law. Corcoran, the cases are legion. The judge, however, was firm in that belief, so firm, in fact, that he indicated his intention to enter a directed verdict on behalf of the defendant at the conclusion of the Commonwealth's opening speech.
Why didn't, okay, given the judge's firm but erroneous belief, but firm, why didn't the Commonwealth at that point move to null pros or do something rather than actually have jeopardy attach?
That, Your Honor, I cannot answer. I've read the transcript. There's a lengthy colloquy between the prosecutor and the judge. I'm not sure that the prosecutor understood what the judge was going to do fully, that is, enter a judgment of acquittal. I think it's part of the rough and tumble, I think, of the district court. Things happen quickly, and I think the judge was less than clear what the disposition was going to be. But again, I can't speak for what was in the mind of the prosecutor that day.
So let's assume the judge did not err, and you had gone to trial on the charge of the possession of stolen property, and the jury had found him not guilty.
Yes.
Is it your view that you could then have charged him with larceny?
It is absolutely the case, Your Honor, that regardless of the manner in which that not guilty verdict was obtained, that in a second proceeding we could certainly charge him with any crime that was not a cognate offense with respect to
Okay, well, that's
to
my
receiving
question.
stolen
Could you have
property.
charged him with larceny?
Absolutely, Your Honor.
Why wouldn't it be a cognate offense?
They have mutually exclusive elements, Your Honor.
And so the defendant basically says that the same offense for double jeopardy is not the Maury elements test that the Commonwealth
Absolutely.
says, but instead, because he says that that applies only in the same prosecution, but that here, where successive prosecutions are at issue, the Massachusetts Constitution requires a conduct-based test and cites to the cases.
Yeah, I think he actually adverts to the Massachusetts common law double jeopardy rule, but the point is just the same, Your Honor. The reality is the governing law in this case could not be more clear, and it's especially clear since this court decided Commonwealth versus Vick.
Vick wasn't subsequent, it was the same prosecution, wasn't it?
Pardon me, Your Honor?
Wasn't Vick the same
Yes,
prosecution?
but Vick did establish the principle for all double jeopardy cases that the standard by which same offenses to be judged.
Isn't there language in Vick that says, you know, it may be somewhat different when you've got, I thought there was language right in Vick that to this point.
There isn't, Your Honor, that there is no suggestion in Vick that a different standard might apply. There's some citation to earlier cases that relate to collateral estoppel, and we'll get to that in a second, which certainly is a related principle that has some application to this case. But even if you think that Vick is less than clear on the point, in the same session as Vick, the court also decided Solomon versus Commonwealth, which absolutely involved seriatim proceedings, and indeed the offenses were very similar. It was receiving stolen property and breaking and entering.
All right, but, so we have an elements-based approach,
Indeed, we do, Your Honor.
for sure. So what about this scenario, though? Because that's not quite this case. This case, jeopardy attached. No null pros was filed, jeopardy attached, we had the trial. So let's say that there's a trial, and somebody shoots somebody on the street, and the charge is armed assault with intent to murder. There's a lesser included or not of armed assault with intent to kill. Jury comes back not guilty. There was a shooting with a gun, all right?
Yep.
And then the DA presents a case to the grand jury for assault and battery with a dangerous weapon, same shooting. Couldn't do that.
Well, in
And
fact,
why
Your Honor,
not?
that case was decided in Massachusetts in 1805 on exactly those same two charges, Commonwealth versus Roby, and indeed this court at that time concluded that in fact just such a prosecution was legally permissible.
But you wouldn't say that today, would you?
Provided,
Same shooting.
Your
jury
Honor,
found
no,
not guilty?
not even the Supreme Court during that narrow window of time when Grady v. Corbin was the governing law ever suggested, indeed no court of which I am aware has ever suggested that there's a same transaction test or a same evidence test or anything approaching that.
So do you think that the
there is
government could do that?
Absolutely, provided the elements are provided the offenses contain mutually exclusive elements, and the Supreme Court directly addressed this in United States versus Dixon in their rejoinder to Justice Souter. They said there's no authority whatsoever for the bald assertion that we have held that governments must bring their prosecutions for non-cognate offenses together, despite the fact that they arise from the same set of facts and circumstances. The government is entirely free to bring them
Was
separately.
that a successive prosecution?
Absolutely, yeah.
So if they both have separate elements in your view, and we can discuss whether you're right about that,
Yep.
why can't a person be convicted of both?
Well, there is a common law rule, a separate and unrelated common law rule that states that a person cannot be convicted of receiving and larceny of the same property, and that's a freestanding
And what is the
principle.
basis of that common law rule, if not that receiving stolen property is recognized effectively to be a lesser included of the theft of stolen property?
It dates back to the era of Blackstone. Blackstone in 1765 was the first person to make this observation, Your Honor.
But how can it not be a lesser included
Well,
of larceny?
the elements are mutually exclusive.
They're
There's a-
not.
But you say that, I mean.
Well, the
if
elements
you go to
of
page
receiving
13,
are,
you go to page 13 of your brief, or
Yep.
Mr. Wittenberg's brief.
Yeah.
Elements, receiving stolen property. The property in question was stolen. The defendant knew that the property had been stolen. The defendant knowingly had the property in his possession. And if you were to add that the defendant stole the property, wouldn't you, for all practical purposes, have the elements of larceny?
Well, if you add an additional element not found in the offense, absolutely, that's the whole point of mutual
That's why
exclusivity.
receiving stolen property is a lesser included.
Receiving stolen property has never been treated as a lesser included for double jeopardy purposes. There is a common law rule that precludes a conviction on both, but it is not grounded in double jeopardy and has never been attributed to double jeopardy. It's a separate, freestanding, traditional principle of the common law that we received.
Well, you say it's tradition, but we have upheld it as recently as today, and although without tradition we'd be like a fiddler on the roof, we generally base it on some reason, and isn't the reason essentially that it's a lesser included?
Well, it's not a lesser included under the standard that this court has articulated for determining what constitutes a lesser included offense. There are mutually exclusive elements. There's a requirement of proof of theft in the larceny context.
Right.
There's a requirement of possession in the receiving
Well, of course,
context.
if you've stolen it, aren't you also possessing
and
it?
the intent is different in both, Your Honor. The intent elements are different in both as well.
What's the intent?
The intent element for larceny is the permanent deprivation. There's no such element in
Well, but
receiving.
he has to know that it was stolen.
The
and it's only
knowledge
stolen
of
if
the
it's-
provenance of the property is an element of receiving.
Well, it's
And I agree.
I'm sorry, is property stolen if it's only borrowed?
And it is also
Sorry, try my question. Is
Sorry,
property
Your Honor.
stolen if it's only borrowed?
under the larceny statute, there has to be a specific intent to,
I
a
know that,
general
I know
intent
that,
to
but for the receiving-
permanently deprive. So
I
a
know that-
borrowing would not meet the permanent deprivation standard, I don't
Take a
think.
deep breath, try my question. Receiving stolen property, the element is the defendant knew that the property had been stolen. If the property had been only borrowed and had not been taken with the intent of permanent deprivation, would it have been stolen?
For the purposes of receiving?
Yeah.
I don't think so.
Okay, so isn't the intent permanently to deprive implicit in the element that it was stolen with regard to the element of receipt of stolen property?
I don't think so, Your Honor. The mental state of the person who takes the property in the first place does not enter into the elements required to convict somebody for receipt of stolen property. How the property came into the possession of the person who receives it and through what mechanism and what was the intentionality of the person who stole it is completely unrelated to the elements in the mental state required for receiving stolen property.
Okay, which means that if I'm sorry, it means that if I, in my view, borrow your car and am found in its possession, and I'm charged with, you claim I stole it, and you charge me with the receipt of stolen property, to wit, a car, I cannot claim as a defense that Mr. Michael lent me the car and that I did not steal it?
Absolutely, Your Honor.
Okay, so isn't the fact that it was stolen an element of the offense?
The mental state that requires awareness of the provenance of the property is part of is one of the elements for receiving stolen property. Absolutely, the mental state, the specific mental state requiring an intention to permanently deprive, that's not part of the mental state. That's not required for receiving stolen property. And indeed, there is no necessity there be any awareness on the part of the person who's receiving the stolen property what the mental state was of the person who stole it. Simply that the property be stolen and that the person who is in possession of it knows that. I understand that we are, like Zwengli and Luther, angels dancing on the head of a pin here, and I understand these are closely related offenses. But nonetheless, under Mori, there are mutually exclusive elements. There are elements found in each that are not found in the other, and
Sure,
that is
but,
the standard.
all right, so,
And they all relate to different.
has the taking of personal property with intent to permanently deprive, but it has to be a taking of personal property.
Transportation, absolutely. Your
So that's fine, but I'm still stuck on this earlier question I have. So someone's charged with rape and they're found not guilty. Can there be a separate prosecution afterwards for indecent exposure?
I don't have the elements in front of me, Your Honor, for those two offenses, and so I would be loath to commit myself, but let me say this, provided there are mutually exclusive elements for those offenses, absolutely that would be the case.
So we don't care about the transaction. So I'm sorry to bombard you with hypotheticals. So if in the first trial, someone's found guilty of trafficking, or not guilty of trafficking, rather, you certainly can't bring a possession with intent prosecution.
Absolutely.
All right, you agree with that? That's
Yep.
a lesser included. But if there was a firearm involved in the trafficking and it wasn't charged, you can certainly bring a firearm case in trial number 2. Is that what you're saying?
Yes. And I have to say that neither in Grady v. Corbin, even when the Supreme Court came as close as it has ever come to articulating what looks like a same conduct test, even then there was never the suggestion that this was the same transaction test, the same evidence test. I understand that.
As long as we line up the different elements, and
Absolutely.
then you can have prosecution number 1 and prosecution number 2.
And as a matter of judicial economy, and as a matter of administrative economy, cognate offenses are ordinarily tried in a single proceeding. As we all know, that's the standard procedure. But you can't confuse the familiar with the necessary, Your Honor. And the Commonwealth absolutely does retain the ability to try cases seriatim where they are not the same offense by reference to what this court has established as the sole basis for determining that, i.e. the elements-based test of Mori.
So for all practical purposes, the Commonwealth gets 2 bites of the apple in
Except, Your
a
Honor.
larceny case.
Except, Your Honor, that there is a collateral estoppel, which will preclude relitigation of issues actually decided in a prior proceeding. So if you're looking for something that will guard against the possibility of endless relitigation of matters already decided, collateral estoppel is the principle which prevents that. And in fact, what I would suggest is, to the extent that Grady v. Corbin had a rationale, the Supreme Court in Dixon ultimately suggested there was no rationale, either historical or jurisprudential, that it was because they were conflating principles of collateral estoppel with principles of double jeopardy.
So there had been a not guilty entered as a result of a jury verdict,
Yes, Your Honor, exactly,
and there had been a trial,
exactly,
and all of these facts had come out, you would be precluded.
exactly, Your Honor.
Although you had answered
Because-
before, I think, that you could bring successive larceny charges because of the difference in elements. So I'm a little confused.
Well, we've
about-
now added facts to the hypothetical. I was operating under the hypothetical of
Could
the
you
present
clarify
case.
what the,
And we were also talking about double jeopardy, Your Honor. And it would not be a double jeopardy bar, it would be a collateral estoppel bar. So in the hypothetical that you first presented me with, not only was I operating under the facts of this case, but also we were talking about double jeopardy. And there would still be no double jeopardy bar, even if there were a collateral estoppel bar. And it is important to remember that for the purposes of collateral estoppel, it is a factual inquiry, not a theoretical inquiry. It is facts actually decided at the prior proceeding, and that's done on a case-by-case basis. Here,
Are we dealing with finality and collateral estoppel? Is that why the jury verdict would have collateral estoppel?
no, the real issue here that benefits, in this case, the Commonwealth, is that we have a clear record of the basis on which the acquittal was entered in the district court, and it was not entered on the basis of any fact-finding. Indeed, no witnesses were presented, no evidence was presented. So we are 100% certain that none of the factual issues that would be in dispute in a subsequent prosecution for larceny were in fact decided in that first proceeding, and so therefore there would be no collateral estoppel bar to any subsequent proceeding. Neither is there a double jeopardy bar because we apply a strict Maury-based test, as the federal courts do and as virtually every jurisdiction in the country does. And so in this rare case, Your Honor, because there is no double jeopardy bar and no collateral estoppel bar, the government, as the Supreme Court has said in Commonwealth versus Dixon, is 100% at liberty to maintain a second prosecution for an unrelated offense. Justice Botsford, I see you are
Nope, that's
shaking
it.
your head.
I'm done.
Okay.
Okay, thank you.
Thank you very much.
Chief Justice Gant, honorable justices, may it please the court, Tim St. Lawrence for Brandon Rodriguez. There's a lot to deal with here, and I guess I'll start with just some of the questions. And I think the reason that you can't be convicted of both receiving stolen property or possession of stolen property and larceny is because the court has said that those are inconsistent verdicts. So one can't be the thief and then also the receiver of that
not.
same stone.
I mean, conceptually.
Because in
isn't it-
theory, a
Isn't
person.
it really a fairness question? I mean, because clearly as the thief, you are receiving that stolen property. You've got to have it in your hand. And you know it was stolen because you stole it.
I see your point. I'm just, what the cases have said as far as you can't be guilty of both is because.
You can't be convicted of both.
You can't be
Or
convicted of.
sentenced of both.
Yes.
Exactly.
Just
You can
like
be
you
tried
can't-
for both.
just
You
like
can
the
be found guilty of
Just like
both.
the ammunition cases
Yes.
that we've had.
Sure.
So it's not really that they're inconsistent, I
Well,
think.
the reasoning of the courts in doing that, because technically speaking, I don't think that under the Maury test, and it's a strict test, and this is where some of the problems are coming from, under the strict Maury test, where we don't look at any facts, we just look at the elements.
Right, but isn't your point that that's fine if you're talking about a contemporaneous prosecution? It's not fine when you're talking about consecutive prosecutions.
Right.
Isn't that your
That's my
main
position,
point?
is that that's the standard, the sole standard, as this court has said, for cumulative punishments in one proceeding. Where we go to successive prosecutions, we broaden the standard. And we do that because different interests are at stake in successive prosecutions versus one proceeding where there's
Do you
multiple
think that the
sentences.
Commonwealth got a raw deal in this case?
I think the facts of this case, you might say that the defendant caught a lucky break if this
Yes,
court
by
were to uphold
judicial
the judges.
error. Judicial error may give him a very lucky break.
Right, but I don't think that's a reason to decide a rule going forward where we're going to have cases that go to a jury. And to that point, you know, we don't know what juries do when they acquit.
What about counsel's collateral estoppel argument that would operate on as a break to such cases that go to a jury?
So if the case went to the jury and he was acquitted of the receiving,
His argument is that collateral estoppel would preclude the government from bringing successive cases
because
because there's been a final determination by a fact finder of facts.
that he's not guilty of receiving, but not that he's not guilty of stealing. So I'm not sure that would, and I'd have to think about it some more. I'm sorry I didn't really prepare on that issue, but I at first blush, I don't think it would operate to stop them from bringing the larceny charge in the second.
Only if they had an element in common. If the two crimes had an element in common, that's when that would come into play. But I guess the notion is that these two statutes don't have an element in common. Do you agree with that?
They may have an element in common. They certainly have, each has one that the other does not.
Element in common in that the property has to be stolen.
Right,
Taking
but
from the property of another with intent to permanently deprive means that the property was stolen, and receiving stolen property means the property is stolen.
right. Just on the basis of
That's okay.
yeah.
I have
I'm
another
sorry.
question I want to
Okay.
ask you, because you say in your brief that for successive prosecutions, you apply a conduct-based analysis. And I looked at the cases that you cite, and I can't find that.
Okay.
You say, according to Vic, that that's what we do, but the way I read Vic, it doesn't say that. It says it may be appropriate. It doesn't say that that's what you do. And so I'm just wondering where we would get the authority to adopt a conduct-based approach when we've adhered to Maury all these 100+ years. Where would I find
Right.
that?
And my argument is that the court has, in its opinions, left it open as far as, again, the court has said, Maury for cumulative punishments. We're leaving it open. There may be a broader test for successive prosecutions. They said that in Crocker and in Vic. Maybe. We haven't decided the question. I try in my brief to show cases in the common law where the court has looked beyond Maury in successive prosecutions. So in a case like Costarelli, where the court says there's different elements, each has an element the other does not have, yet, based on the facts of the case, we're going to say that these two offenses are, for double jeopardy purposes, they're the same offense. So the court has explicitly looked beyond a strict elements-based test to look at the actual facts of the cases. And Costarelli's one case that did that, and I would suggest that some of the older cases, the language is broader than a strict elements-based test. And the court would and has looked to the actual facts in determining whether two offenses are the same. So it's Maury, and if I would suggest to the court that the common law would, in successive prosecutions, would be a Maury test. If the crime has, each crime has a different element than the other crime, then the court would then proceed to a conduct-based test where you could look at the facts and determine whether the two offenses were in fact the same offense for double jeopardy purposes in successive prosecutions. I just wanted to, and it's not law because it was in a concurrence, but Justices Kaplan and Liaco said in Gallarelli, in cases of successive prosecutions, the same elements test works out as an arid and inadequate doctrine. And I think they were right. And I think that this court has recognized that over the years and has gone beyond a strict elements-based test and looked at facts and conduct. And I think the proof of that is the amount of times that this court has had to reiterate that in the case of cumulative punishments, the test is Mori. The test is Mori is because the courts and the common law recognize that in certain circumstances, especially and maybe only successive prosecutions, we need to look beyond a strict elements-based test. And so that's the position of Mr. Rodriguez. If the court has no questions.
Are you aware of any case in which collateral estoppel has been invoked with regard to a successive prosecution? That we've ever applied collateral estoppel in a criminal context?
I can't think of one. I can say that the famous case from the Supreme Court, Ash v. Swenson, it was an armed robbery of a poker game. And they tried him as to one victim first, and he was acquitted. And then they brought robbery charges against him as to a different victim.
Didn't we last year have a, yes, thank you. What's it called?
Commonwealth versus Durazio applied collateral estoppel in precisely the context that I explained
Okay.
before the court.
So I would ask the court if I could take a look at that case and get you a 16L letter within the week.
Yes, I'm just wondering, I mean, of course, the jury would have said, if it said not guilty, would simply say not guilty. And how would we know that the jury found that he did not knowingly have the property in his possession at the time alleged? He could have stolen it, but then the charge would be, the possession would be at a certain point in time that may have been subsequent to the robbery. So how would we know that the jury had not acquitted on that basis as opposed to the other elements? I'm just trying to sort out how we would apply collateral estoppel.
It seems to me that it would be difficult, even apart from the fact that, you know, juries' verdicts sometimes are based on lenity and compromise and even mistakes. So I'm not sure exactly how that would work in practice. And
It is the case, though, right, under the, at least made very clear in, is it Corcoran? Is that, what's the name of the appeals court case? That's correct, Your Honor. Corcoran.
Corcoran, right.
That you can, at least the appeals court said, and it seems to me with reason, that proof that somebody stole the property can well satisfy proof that of receiving stolen property, right?
Right.
I mean, you can use the same evidence and come out. I mean, you can't be sentenced on both, but that same evidence would be fine for either, right?
Right.
So that helps you, doesn't it, in terms of the successive prosecution? I'm just sort of looking at this language. I think it's quoted out of Azer, if I'm pronouncing that correctly.
Right. I think that's right.
That if on the earlier complaint, the defendant might have been convicted by proof of the facts charged in the later one, and acquittal upon the earlier one will bar the later one? Isn't that,
Exactly,
isn't
and
that what you're
that's
saying?
right. That's the broader language I was talking about. That would allow a case like this, where we have that common law saying you can be guilty of receiving even if they show you're the thief. Okay, and that was the theory the Commonwealth was pressing. That then under that broader language of Azer and it's some older cases, that this case would fit squarely within that and would be the same offense as a result.
Okay, there are no further questions.
Thanks.
Thank you.
Thank you.
And we'll take our morning break.